This lecture discusses how legality affects the validity of a contract. To be enforced in court, a contract must call for the performance of a legal act. Courts will not enforce contracts that are contrary to state or federal law or to public policy, which is just a simple concept here. To allow a person to profit from his or her wrongdoing is clearly contrary to the mores of society. Contracts definitely are illegal when they call for illegal acts. But we're going to look more in this lecture as to how they violate public policy. So you'll see here that the outcomes we are going to gain in this lecture include contracts that may be contrary to federal or state statutes, contracts that are contrary to public policy, state circumstances in which covenants not to compete are enforceable, and understanding the consequences of entering into an illegal agreement. Statutes prescribe the terms of some contracts requiring certain clauses or specific wording and prohibit other contracts on the basis of subject matter, the time at which they are entered into, or the status of the parties. Any contract to commit a crime is a contract in violation with the statute and is not enforceable. If the contract is rendered illegal after it has been entered into, it is discharged by law. Most states have statutes that set interest rates for various types of loans. Making a loan at a higher rate constitutes usury. All states regulate gambling. Nearly all states operate lotteries, allow horse racing, or permit games of chance such as bingo for charitable purposes. A few states allow casino gambling. And then licensing statutes. All states require certain professionals to obtain licenses. When a person contracts with an unlicensed individual, the contract may not be enforceable depending on the underlying purpose of the licensing requirement. If the purpose is to raise revenue, the contract normally will be enforceable. If the purpose is to protect the public from unlicensed practitioners, the contract will be unenforceable. So, because of negative impacts on society, some contracts are contrary to public policy and therefore they're unenforceable. These include contracts to commit immoral acts and contracts that prohibit marriage. Contracts in restraint of trade, which is like price-fixing agreements, adversely affect the public because they inhibit competition. Also, they usually violate some type of antitrust statute. Now, accepted are restraints that can be considered reasonable. Now, in covenants not to compete, a covenant not to compete is often in a contract for the sale of an ongoing business. This enables a seller to sell and a buyer to buy the goodwill and the reputation of a business. A seller agrees not to initiate a similar business within a certain area for a specified period of time. But the restrictions must be reasonable. Oftentimes we see in these types of covenants not to compete that if they are extreme, then the courts will not allow them. A covenant not to compete may accompany an employment agreement if the restriction is no greater than necessary to protect a legitimate business interest. What constitutes a reasonable time period online may be shorter because the restrictions are global. The laws governing the enforceability of covenants not to compete vary from state to state. If a covenant is unreasonable in time or geographic area, to prevent undue hardship, courts in some states convert the terms into reasonable ones and then enforce the covenants. Other contracts that are contrary to public policy or the law include contracts for the commission of a tort, contracts injuring public service, and agreements that obstruct the legal process. Contracts in which a party promises to discriminate in terms of color, race, religion, national origin, or sex, for example, a promise not to sell property to a member of a particular race, are contrary to statute and contrary to public policy. Contracts that require a party to commit a civil wrong or a tort are contrary to public policy. Contracts that interfere or conflict with a public officer's duties, such as a contract to pay a legislator for favorable votes, are contrary to public policy. To prevent conflicts between public and private interests, statutes require many public officers to liquidate their interests in private businesses before serving as elected representatives. Other statutes merely require that while they are in office, they take no part in the operation of or decisions concerning a business in which they have an interest. Agreeing to delay, prevent, or obstruct the legal process, such as agreeing to accept $1,500 to delay a trial, for example, is illegal. Agreeing to suppress evidence in a legal proceeding or to commit fraud on a court is illegal. Offering jurors money for their votes is illegal. Offering to pay one witness more than another is contrary to public policy, but most trial witnesses, except expert witnesses, are paid a flat fee for expenses. Extra money could provide an incentive to lie. A promise not to prosecute a criminal offense in return for a reward is void against legal policy. A reward given under the threat of arrest or prosecution is also void. Here's a great example. The most beautiful baby in the world. Lawrence Schwab, a former windshield repairman in Detroit, Michigan, was facing financial problems. He's out of work. He's behind in his mobile home payments. He had 3 children to feed, and being desperate to obtain funds, he decided to sell the youngest of his 3 children. To that end, he created a videotape titled "The Most Beautiful Baby in the World" to show to prospective buyers. Unfortunately for Schwab, his babysitter informed the police of his plan, and he was caught in a sting operation when undercover police officers posed as a would-be adoptive family. Schwab accepted $10,000 from the officers as a down payment on the $60,000 contract price. If a case involving a similar contract came before a civil court, the court would likely deem the contract void against public policy. Schwab's was a criminal case, however, and a significant question immediately arose. What statute had Schwab violated? Until September 1st of 2000, Michigan was one of about 25 states that did not explicitly outlaw the sale of children. Shortly after Schwab's arrest drew attention to this oversight in state law, then the Michigan legislature passed a bill making trafficking in humans punishable for up to 20 years in prison and a $100,000 fine. At the time Schwab tried to sell his daughter, however, the law didn't exist. At worst, the only state crime that Schwab committed was attempting to profit from an adoption, which is subject to a penalty of 90 days in jail. The bottom line is, occasionally bizarre cases such as this one alert state legislators to loopholes in their laws. Note, though, that the prosecutors in Schwab's case found other ways to keep Schwab in jail for a while, at least until his former wife claimed custody of the children. The prosecutors charged Schwab with child abandonment, driving with a suspended license, and violating his probation, stemming from an earlier drug case. How lovely. Moving on here to unconscionable contracts or clauses. In some circumstances, bargains are so oppressive that a court will relieve an innocent party of part or all of the contractual duties. Now, procedural unconscionability concerns how a term becomes part of a contract. It may involve a party's lack of knowledge or understanding of a term due to inconspicuous print, unintelligible language, or lack of opportunity to read the contract or to ask about its meaning, such as may occur in states involving adhesion contracts. Substantive unconscionability describes contracts or terms that are oppressive, provisions that deprive one party of the benefits of the agreement or leave that party without remedy for non-performance. Contracts entered into because of a party's vastly superior bargaining power may be deemed unconscionable. Is it unconscionable for physicians to prescribe medications online? Anyone with an email address has undoubtedly received scores of messages offering to sell prescription medications, such as Viagra, online. In the past, someone who wanted a prescription for a certain medication, whether it was for allergies, weight loss, or sexual enhancement, had to see a physician and normally undergo a physical exam to see if that medication was appropriate. Today, however, it is possible to enter into a contract to obtain a prescription for and order many medications via the Internet without ever setting foot in a physician's office. Contracting with a physician online to receive prescription drugs may be ill-advised, but are such contracts unconscionable? Well, the hallmark of an unconscionable contract is that its terms are so oppressive, one-sided, or unfair as to shock the conscience of the court. Thus, the issue is whether Internet prescriptions contracts are so unfair that they shock the conscience of the court. After all, physicians are trained to examine patients, diagnose medical conditions, and evaluate possible treatments. A physician who is prescribing medication for a person online, however, has no objective way to determine the person's health status or whether the person understands the risks involved. For example, in the online context, a physician cannot tell if a person is truthfully reporting his or her age or weight, which can significantly affect whether a medication is recommended. In addition, physicians who prescribe drugs online cannot monitor the use of these drugs and evaluate their effectiveness. To date, only a few courts have addressed this issue, and no court as yet has held that prescribing drugs online is unconscionable. So, for example, in 2003, in a case before the Kansas Supreme Court, the state attorney general claimed that it was unconscionable for an out-of-state physician to contract with residents to prescribe drugs via the Internet. The case involved 3 Kansas residents, including a minor who entered contracts on the web to obtain prescription weight loss drugs, Meridia and Phenermine. The court held that the physician's conduct in the resulting contracts were not unconscionable because there was no evidence that the physician had deceived, oppressed, or misused superior bargaining power. The website used by the physician had included a great deal of general information about the specific drugs and their side effects, online questionnaires to obtain medical histories and waivers of the physician's liability for the prescriptions. The website had also provided an online calculator for body weight so that a person could determine if she or he was 25 pounds overweight as required to obtain a prescription for Meridia. Because the court found that the individuals had gotten exactly what they bargained for, the prescription medications they sought, the court refused to step in and declare the contract unconscionable. Often held to be unconscionable are contract clauses attempting to absolve parties of negligence or other wrongs. These are exculpatory clauses, clauses that purport to release parties from all liability for damage or injury arising within contexts related to the subject matter of the contracts. In general, an illegal contract is void. Exceptions include justifiable ignorance of the facts, where a party who is relatively innocent can offer recover benefits conferred under a partially executed contract. An innocent party who has fully performed may be able to enforce the contract. So, for example, a trucker who unknowingly delivers illegal goods may be able to recover the delivery fee. Members of protected classes, if a statute is clearly designed to protect a certain class, a member of the class can enforce a contract in violation of the statute. Despite statutes limiting excessive working hours, for example, an employee who works overtime can recover overtime pay. Similarly, if an insurance company violates an insurance sales regulation, the buyer can still enforce the policy. Withdrawal from an illegal agreement, if the illegal party of the bargain has not been, if the illegal part of the bargain hasn't been performed, a party can withdraw from the bargain and recover whatever he or she rendered in performance or its value. A bettor can quit an illegal bet, for example, before the winner is paid. Each of 5 co-workers we're going to look at this next slide to learn about something in the chapter here. The 5 co-workers receives a free lottery ticket from a customer. The co-workers orally agree to split the jackpot if one of the tickets turns out to be the winning one. When one of the tickets is a winner, its holder decides not to share the proceeds. The other co-workers file a suit to collect. Well, is the co-workers' agreement enforceable? You would think initially it would be. You would think it's entirely legal, but since it's an exchange of promises to share winnings from the parties' individually owned lottery tickets in the uncertain event that one of the tickets wins, this is an agreement founded on gambling principles. And because of the fact it is founded on gambling principles, it is considered void because that goes against public policy. So there you have it. Feel free to review this as many times as you need to.